Welcome to this Queen Mary School of Law panel event. The panel is on the promise and perils of algorithms in public administrative decision making. The background to the idea behind the event and the topic was my work at the S Centre, which is a charity which deals with European human rights, and the use of algorithms in particular as used by the Home Office with regards to the EU settled status scheme, and also in respect of the DWP and their use of algorithms in assessing benefits claims. And we've got a great lineup of speakers tonight, and I'm just going to introduce the chair who will take it from here. So really pleased that Professor Alan Dignam can be the chair. He's an academic here at Queen Mary University of London, as well as having held numerous visiting fellowships. He's advised governments, NGOs and corporations on corporate law and governance reform, and was appointed as an honorary QC in 2020. His major research interests include the application of constitutional rights and human rights to corporations, and in particular the impact of artificial intelligence on corporations. He's exploring this issue as a Wellcome Trust funded network member since 2016, and has published the first of a series of papers in 2019 entitled Artificial Intelligence, the Very Human Dangers of Dysfunctional Design and Autocratic Corporate Governance via the Social Science Research Network. So I'm going to hand over to Alan, who will introduce the other speakers and give some background to the use of algorithms more generally.
Sorry, 2 years on and I'm still getting my muting wrong. Welcome everybody, and thanks Matthew for setting up this session and for inviting such a great group. So I have two functions. One is to just introduce the generality of the topic, which I'll do in a moment. But it gives me great pleasure to introduce our panel because it is a really fantastically interesting group, which holds out the promise of really digging into some of these issues about the use of automated decision-making in or algorithmic decision-making in the public sector. So the running order for today is we have Claire Hall on first, who's going to talk, who's solicitor and strategic litigation lawyer at the Child Poverty Action Group, who have experience of dealing with these types of systems in the universal credit system. But Claire's going to set out, I think, a kind of a broad view of what we're moving to some sort of digital welfare state. Then after Claire, we'll have Joe Tomlinson, who's a senior lecturer in public law at the University of York and is a member of the academic panel at Blackstone Chambers. And in a very timely way, Joe has finished a book recently on the Home Office immigration systems, or the rollout of automation in those systems, which he's going to share his insights on with us. And then we have, from the United States, we have James Petrovsky, who's an attorney in the United States who specializes in labor and employment issues, is the managing partner of Hertzfield and Petrovsky, which is primarily a union labor law firm. And James is going to give us insight into the experience in the United States and some of the challenges he's experienced with algorithmic and automated decision making. And then last but not least, we have Keir McAndrew, who's a barrister at Moncton Chambers, who has a practice covering competition, information, EU, sports, tax and administrative and public law. And Keir's going to focus us in on the relationship between data protection and AI algorithmic decisions. Those of you who are aware of sort of global developments in this area will know that this is a sort of key area for regulators now, or the direction of regulation around the world is moving towards data protection and privacy being extremely important. So that's our panel. If I can introduce the topic in a broad way, I'll start with really the a little bit that algorithmic decision making is not new, and many of the problems that we've experienced recently, probably in the last 5 years, are really old problems. Partly because we've got the sort of large tech companies with very little experience of automated decision making, particularly with more recent statistical AI decision making, sort of repeating mistakes again and again and again that we have seen over time with computerized decision making. Because in some ways, essentially, we have a human problem in technological form, where it's not just that coding itself historically can be buggy, it can be badly done, it can interact badly with hardware, the environment it's in can be problematic for its outcomes, but often it is, when we boil it down, the human who programmed the code that was problematic in a sense. The most famous example of really algorithmic bias historically is the St. George's Hospital case, where the hospital produced a program that would help it with its hiring. And what occurred was really interesting. The computer system eliminated anybody with a non-English name. It eliminated people from consideration for jobs if they were non-British nationals. Generally, their addresses were not, if you want, in the right place. And it generally eliminated women from consideration for roles in the hospital. And it was because the people who programmed it tested it against the hiring it had historically done. So in effect, it was just sort of capturing a bias of a particular moment, which went on to be enormously troublesome over a decade of using this thing. So it's not new. Perhaps the issues were easier to see there. Normal code is fairly transparent, even though it can be buggy. But as we've moved into more complex black box type systems, it becomes a little bit more tricky to work out exactly what's going wrong. We've also got a lot of sort of overselling by the tech industry and poorly developed products that are being sold into the private sector. Relatively brittle systems that are developed for other functions that are adapted and used in decision making on social welfare or immigration, and that are following broadly heuristic processes. You know, the best way to describe this is that they're educated guesses these systems are producing rather than something more refined. And there are systems that can be pretty good, but most of the best sort of automated or algorithmic decision systems don't exist in the commercial sector, and they're not sold into the public sector. They're very expensive, but even they reach about 90% accuracy against human decision making. Now, I don't mean human uncertain decision making. I mean against, is it a cat or not? And that's grand. If you want to search for a cat and you want to use an automated decision search, great. It doesn't matter that 10% of the cats are not in fact cats. But whether you're going to get deported or not, or whether your social welfare payments are going to be stopped, it does matter. Even in high integrity systems, 10% of them will be mistaken. And in reality, the ones that we see in operation in the public sector tend to be much, much lower level accuracy. So we have a problem in the way that they're developed and a problem in the way they're sold and the way they're tested as well. If the tech industry was a pharmaceutical company, they would have a basic product that they would just give to everybody to see, well, does it work or not? So there's a sort of culture issue about the way that these systems have been developed, which impacts on how they operate in reality. Now, I suppose the title of this session is The Promise and Peril, and I think we're going to spend quite a lot of time on the peril. So let me just try and set out the promise part. Mass computing power, and particularly more recent pattern finding AI tech, has the potential to remove routine, repetitive tasks from humans. It might be problematic for employment in the future, but certainly it promises something like freeing people up for leisure, high-skilled work. It can speed up scientific medical advances, and it can allow for, particularly in the legal arena, sifting evidence has become it's become useful in sifting evidence. Famously, the Rolls-Royce fraud trial could never have reached its conclusion if it wasn't for automated pattern recognition software. I mean, it's rudimentary AI stuff. It's really a sort of word search. But because of the scale of documentation and because we had the computing power to be able to use this, it opens up new vistas, things we just could not do as humans. One thing that is in this, it's sort of hard to really navigate, is the unknown innovations. Railways were relatively rudimentary until we got clocks to a sophistication of really high accuracy, which then opened up national and global economies. So there's a hope in this, that there's something in this automated decision-making that offers a promise for a better future. For me, the way things are operating at the moment is there's a bit too much of the sort of hype around the promise of this and not enough concern really in the decision-making circles that implement these automated systems around the heuristic element, that these are, they're really tricky systems. And when you fall foul of them, it's very difficult to unpick the decisions. So without further ado, I will hand over to our first speaker, which was Claire Hall, who, as I said, solicitor and strategic litigation lawyer for the Child Poverty Action Group. So over to you, Claire, for your thoughts.
Thank you for that introduction, and I'm really pleased to be joining today because I do think it's a really important topic and also one that's sort of continuously evolving at the moment, so there's plenty to talk about. I'm going to talk from the perspective of acting for individual benefit claimants who are on the receiving end of algorithms which are used in the social security system. So there are a few different areas within what, as Alan mentioned, gets termed the digital welfare state, in which there is an increasing use of algorithms. And that trend is by no means limited to the UK, although that's where I'm going to focus on today. So I'm going to focus on universal credit, which, as many of you might know, is now the main means-tested benefit for working age people that we have in the UK. And I'll give a bit more background on how UC works in a moment. But the reason for focusing on UC is partly because it's an area that it's slightly easier to see what the issues are relative to other areas where algorithms are being used in the social security system, such as in detecting fraud and error. And it's also because the scale is huge, with around 6 million claimants on UC now. I think it's also useful because some of the technology which underpins it is not necessarily complicated. Well, I'm not saying I could design it myself, but it's not necessarily complex machine learning or AI. So I think it's useful to sort of have an example where even fairly basic algorithmic systems are being used. So UC is a digital by default benefit where claimants make their claim via digital means and then also manage their claim and interact with the Department for Work and Pensions digitally. But there's also a significant amount of automation and algorithmic decision making that goes on behind the scenes in the administration of UC. So I'm going to use a judicial review that Child Poverty Action Group brought a couple of years ago as an example. And that challenged how a bit of the UC system works. It's called Johnson and Others against the Secretary of State for Work and Pensions, if anyone wants to look it up afterwards. But and so hopefully while what I'm talking about is sort of grounded more in practice than in theory. Hopefully this case will hint at a few issues that have some wider application when we're thinking about algorithms in public administration more generally. So as Alan hinted at, might be the case, I am focusing more on the perils than the promise of algorithms, because invariably I do see the side of the system where something has gone wrong for people. And often it is on a big scale with large groups of people affected. And I think that in itself is a feature of algorithms being used in social security and probably more widely, in that when there is an issue, it's unlikely to result in a one-off bad decision or a mistake, and it's more likely to be systemic. So before I launch more into the perils, I will say on a positive note that the high levels of automation in UC played a huge part in enabling the system to cope with the influx of claims which were made at the start of the pandemic in March 2020. And I think that is a fantastic example of some of the advantages of algorithmic systems in the public sector when they work well. The system didn't crash. We didn't have physical queues around the block outside of DWP offices. And crucially, people got money that they needed quickly after they'd suddenly lost their jobs. So in order to explain the issue in the Johnson case, it's worth me saying that universal credit is what is sometimes called a high universal credit assessment period. So people have UC assessment periods which start on different days of the month.
We lost you there for a moment. Could you
what was the last thing you heard?
Go back 10 seconds in your thoughts.
So did you hear me saying some of the positive stuff?
Yes, you don't. You just.
I think you were about to talk about universal credit. What universal credit was, Claire.
Sure. Okay, so I was saying it is, actually, I'm going to turn off my video just in case that happens again, if that's okay. And then hopefully the sound will be fine. So universal credit is a hypermeans tested benefit, which means that the amount of benefit that people receive each month depends on what other income they've received in the previous month. And that's called a UC assessment period. So people have assessment periods which can start on different days of the month, and that just depends on when they first made a claim. So another bit of relevant background that we need to understand this case is that employers across the board in the UK have to report what they're paying their employees via HMRC systems for tax purposes. So for a universal credit claimant who is also an employee, that HMR system will feed information about their earnings in real time to a DWP system, which then automatically feeds a subset of that data into the universal credit calculator. And then the UC calculator can automatically work out how much benefit they should get paid that month. So the specific problem faced by the 4 claimants in the Johnson judicial review was that their monthly pay date from their employers clashed with the date that their universal credit assessment period dates fell on each month. So what that meant was sometimes in certain months, when their pay date fell on a weekend or a bank holiday and they got paid slightly early, or it otherwise shifted slightly because they were contractually paid on the last Friday of the month, which moved around by a few days. On those occasions, they would receive 2 monthly wage packets in one universal credit assessment period. And that artificially inflated the amount that the computer system recognized that they were receiving as income. And the consequences of that were huge fluctuations in their UC payments. So the impact of this on the claimants and their children when this happened was really serious, and the court did recognise that. So all the claimants in the case were working single mums. They were already managing on very tight budgets month to month, They were paying for childcare, rent, bills, and all of their other costs out of their wages, which were being topped up by this UC payment. So when their universal credit dropped unexpectedly, this left them unable to pay their bills, their rent. It left them needing to borrow money, resulted them getting into debt, being forced to rely on food banks. One of the claimants was threatened with eviction by her landlord. One was taken to court for non-payment of her council tax. And another had experienced such stress in trying to cope with this issue, happening repeatedly over different months, that she'd actually made 2 attempts to take her own life. So in defending the case, the Department for Work and Pensions accepted the fact that these claimants faced reduced payments from time to time, and that was arbitrary, and that there was no policy reason for why this group should get less universal credit. Instead, it was just an inadvertent consequence of how the data flows into the UC computer systems had been set up and how the UC calculator functioned. And because the secondary legislation is very detailed on the workings of UC, both the claimants and the DWP's view from the outset was that the regulations, which effectively mirrored how the calculator worked, left no room for discretion.
I think we've lost Claire again. Can anybody hear Claire? No. Claire, we've lost you. I don't know if you can hear us. Girls, are you able to...
I think she's just left the room, so she might rejoin us.
Might rejoin, yeah.
Oh, there she is.
I'm so sorry. It just dropped out, but I am back.
Right, great.
Could you tell me where you heard up to?
The Department of Work and Pensions accepted things, the data flow calculation.
So I think both parties essentially agreed that because the regulations reflected how the calculator worked, there wasn't any discretion for human decision makers to fix the issue for the claimants. So ultimately, the Court of Appeal characterised the issue essentially as a failure by the department to come up with a solution for this group. And the court found that the operation of the regulation themselves on this group was irrational, and concluded that no reasonable Secretary of State would have struck the balance in the way that they did in this case, which is essentially applying a classic Wensbury unreasonableness test. And this conclusion by the Court of Appeal was partly down to them being willing to accept that it was possible, or it must be possible, to put in place a solution for this group in a way that wouldn't fatally upset the computer. And that was despite the DWP in court relying on evidence which stated that it would cost around £7.5 million to change the computer system, and would require a major system overhaul to fix it. So the court also had regard to a number of different factors in deciding that. And that was included the size of the cohort that was affected, and the arbitrary nature of the issue and of the consequences for them. We obtained declaratory relief from the court, which meant that they left it to the Secretary of State to come up with a solution, which I think wasn't surprising given the considerations around the evidence about how much would need to change in the computer system in order to fix the problem. In the end, the Secretary of State introduced amending regulations 5 months later, which essentially gave human decision makers powers to move one wage payment into a different UC assessment period. So at that stage, they didn't change the automated system. Around a year after the court decision, they did then introduce an automated way of identifying people who were affected by this issue. But once those people were identified, they still used a manual adjustment to move the wage payment into a different assessment period. And we do still see cases where people fall through the cracks of this automated identification system and still have to raise it themselves to get it sorted out. So I guess it still remains to be seen if this case is a bit of an outlier in the courts in terms of it being willing to conclude that high threshold for rationality is met in public law. And there have been cases since where this case has been said to be restricted to its specific facts. I think there's something interesting in that the court had to consider whether a solution was possible without fatally upsetting the automated system. Although that consideration has actually been used against claimants in a different case by the Court of Appeal, because in that case, the claimants didn't propose a fully worked through solution as to how the system could have been designed differently without disturbing sort of the architectural design of the universal credit system. So I think with a couple of interruptions where I dropped out there, I do apologise for that. I'm probably up on my time, so I will hand back to Alan, if that's
all right. Thanks, Claire. Yeah, we will.
Just before we move on, just because it's very specific to what Claire's talk was about, Laura's asked just briefly what evidence did the claimants adduce, if any, to show the feasibility of the changes that they needed to see of the universal credit system.
Yeah, so in the Johnson case, the court didn't require that from the claimants, which I think, given that we're talking about 4 individual benefit claimants who don't necessarily have any insight into the workings of the system behind the scene, they weren't required to provide that evidence. In the other case that I mentioned, where the absence of a solution being proposed was sort of held against the claimants. Again, it was more the case that they didn't know they were required to do that, so they didn't advance that evidence. And I think, although I should say CPAG were acting in that case as well, and I think although we probably, as an organisation, would have been able to sort of make some suggestions to possible solutions, I can see that avoiding being pulled into that requirement might actually be really important, because it shouldn't have to be for the people affected by these systems to be able to come up with improvements for the design to solve the issues that they're subjected to. Hopefully that answers that question.
Great, thanks, Claire. Okay, next up we have Joe Tomlinson, who's, as I've already said, but I'll say again, senior lecturer in public law at the University of York, who has just finished a book on Home Office automation of the immigration system. So I'll hand over to Joe. Away you go.
Super. Thanks, Alan. Can I just check you can see my slides?
Yeah, got it.
Great. So I'm going to say a little bit about the use of automation in immigration administration. And a lot of what I'm going to say is going to echo what Claire has said about welfare administration. So there are definitely common patterns across different sectors. So I wanted to start with this news story which appeared in The Guardian in 2019. And it was a story which didn't mention automation. It was a story about how couples wanting to get married were facing what were referred to as insulting investigations, where they were investigated for potentially trying to organise a sham marriage. The report in The Guardian essentially tries to set out the nature of some of these investigations. So this section of the article explains how couples and lawyers describe wedding ceremonies being interrupted so that home office officials could question people about their sex lives, an official finding a nude picture on a person's phone and showing it to others in the room, and even dorm raids carried out to check if couples were sharing a bed. It continues, in one case, a couple were told their relationship could not be genuine because they were wearing pajamas in bed. In others, people have been detained for months after being wrongly accused of entering into a sham marriage. So a number of years after that article was published in The Guardian, the Bureau for Investigative Journalism, in partnership with the Public Law Project, did some further research and found that an algorithm was at the centre of the mechanism used to trigger those investigations. So the algorithm behind sham marriage investigations essentially sifts couples into red and green risk categories. It does so on the basis of 8 criteria. And if you, on the basis of those 8 criteria, if a couple is put in the red category, they then therefore face further scrutiny, further investigation, and potentially different outcomes based on being put into that category. So I started with this example because it seems to me this is a typical, increasingly typical example of the use of automation in the UK immigration system. So what we see here is there is no specific legal authority being set out for the use of automation. Instead, automation is simply handled as an operational bureaucratic issue. It's a mode of implementation rather than something that needs legal authorization. We see automation both replacing and supporting human officials in making decisions. So it's replacing certain decision-making functions, but officials are not entirely pushed out. They still have a role of investigating, etc., etc. We see very limited transparency. So as I said, we don't know what 8 criteria people are assessed on. There's been various requests to see those criteria and the Home Office are not willing to disclose them. We know very little about the impacts of this system. Doesn't seem to be any effective evaluation around it. There seems to be very minimal evaluation. We don't know if it has a discriminatory impact. We don't know how good it is at actually detecting sham marriages. So there's very little evidence on the impact of this system. And another really important thing, which is something that Claire mentioned, is this is a really simple piece of automation. It's data going in, a few functions are done, and then a decision is made. People are put into categories. And this is something that we see a lot in the public sector. For all the talk of complex AI and machine learning, most of what is affecting people day to day, at least in the immigration system, from my research, appears to be much more simple automation. So less AI, more if X, then Y. So why is this happening in the immigration sector? Well, it's really important to think about the realities of immigration decision-making. So really simply, it's a tough job. Often caseworkers in the Home Office who are making immigration decisions will typically be junior staff. They may have supervisors supporting them, but they're often junior staff. Staff often come and go, so there's a high turnover of staff. Caseworkers have to take a lot of decisions, usually quite quickly. They often have discretion as to how to, as to the outcome. So they have to think carefully, despite those pressures, about how to exercise that discretion. Immigration law and policy is enormously complex. Anybody who's ever looked at the immigration rules will realize that they get changed really routinely. They're changed every couple of months, and usually there's massive amounts of changes. Officials have to get their head around that changing law and policy, just like lawyers who are trying to challenge administrative decisions have to get their head around it too. Decision makers in the immigration context, often for very good reasons, have incomplete evidence upon which to found their decisions. So, for instance, people might not be able to access documents. So when they request to receive a certain status, they might not be able to put forward the full and best evidence in support of that application. And that creates a dilemma for decision makers. And of course, all of that job takes place within a very intense kind of political environment where decision makers and the Home Office more broadly are under pressure from one side of the political spectrum to be hardline in immigration, and on the other side to try to develop a more humane approach to migration issues. So why automate? Within that context, automation has a lot of attractions from the government's point of view. So government is generally getting more confident with technology. Ever since the government digital service has been set up in the UK, the government has become much more confident about IT not being a disaster zone as it was historically in the UK, UK government, I should say. So government itself is becoming much more confident in deploying technologies. The UK sees itself as a world leader in digital government now. At the same time, the availability of technologies has increased and is constantly increasing. The private sector is now very able to provide technological solutions to the government on a contracted in basis. The prospect of automation often, at least at a superficial level to the government, comes with the promise of lower costs. So all that decision making around immigration costs a lot of money. It costs a lot of money to employ people, to train them, etc., etc. So one of the promises here is that it will lower costs for the government and ultimately lower costs for the taxpayer of this area of government. Automation might also arguably lead to better decisions from the government's point of view, so it might create more formal consistency. And if the government so chose, it can also collect data through automated decision-making processes better and potentially improve decision-making in that way. So when you look at this from the Home Office's point of view in relation to immigration systems, I think the question that they're asking now is not should we automate, but why shouldn't we automate a lot of the processes that we're responsible for? So this creates a range of challenges for lawyers because we know that those promises don't always come through, and often, as with the example I started with, they create harms, or at least risks of harms for individuals, and particularly often for vulnerable individuals. So there's a range of challenges for lawyers who are looking at this question from the outside of government. I just want to wrap up my remarks with a few points on what I see as some of the most important. So lawyers responding to this have to deal with something which is evolving at a very quick pace. These kinds of systems are being deployed in different departments and different areas of government very quickly. So keeping up with the fast pace of development here, can be a real challenge. It's also the case that there are multiple technologies in place. When we talk about AI or automation, that covers a vast range of different technologies. For instance, you could be talking about rule-based automation or automated facial recognition, all kinds of technologies which are ultimately automation or can be described as automation and AI are being deployed. Differences in technologies will, in my view, require us to think differently in legal terms about the responses to them. And we're definitely in a period of experimentation at the moment in terms of the government's use of automation. So we're going to see lots of trials being deployed. We're seeing lots of trial use of technologies in certain contexts. So for lawyers, I think there's no single overall answer as to whether automation in government bodies is a good or bad development, but what we really need to focus on is doing detailed systems analysis and really digging into local system issues, or in particular policy areas. So for instance, studying the use of automation in housing or immigration or social security and trying to understand what the issues are. And that analysis needs to be, in my view, one that's both top down, so thinking about why are these systems being adopted, how are they being designed and deployed, but also, and this is really important, from the bottom up, so how are people who are subject to these systems, how are they being affected by them, how do they perceive them, how do they experience them? And there's a need for lawyers here, I think, to work with other disciplines to produce this kind of analysis. So often, a lot of the automation that we see in the Home Office and the immigration context, but this is true across the board, is done behind the scenes. So a lot of what we know about what's going on has come through partnerships with journalists, for instance. So there's a real need to work with other disciplines, not just computer science, although computer science is important, but other disciplines to really try to wrap our heads around this issue. And my final point is that there is in the UK, or at least in public law, I think, a real lack of certainty around the application of existing legal standards to some of these new systems. And that's a challenge because we have to think about how existing standards and principles apply, but it's also an invitation for creative public lawyers to bring new and innovative challenges. I will stop there.
Great, thanks, Joe. All right, so next we have James, who is the managing partner at Hertzfield and Petrovsky, labor law firm in the US, and he's going to share with us some of his experience of dealing with these issues in the United States. James, over to you.
Thank you, Alan. Yes, I'm James Petrovsky. My background is primarily in labor and employment litigation, but that has included a significant volume of work in civil and human rights litigation as well. And so my perspective on the issues we're talking about today is based in litigating what appear to be simple seeming problems that received, in my opinion, overly complex solutions. And I think that's one of the great challenges of algorithmic decision making as we move forward. These experiences have arisen, like I say, from very simple problems such as attendance programs by employers, where employers, rather than carefully tracking the reasons why an employee might have missed work, instead simply says, well, anytime that you miss a scheduled work shift, we'll record that and apply points, and eventually if you receive too many points, you'll end up in some type of discipline, perhaps even termination from employment. That's become far more complex when you start digging into, still in the employment setting, into complex timekeeping systems, especially for hourly paid employees, where what should be a simple act of punching clocks in and out at the beginning and start of shifts becomes far more complex as employers try to sort data in different ways, sort time in different ways. Some of it gets paid, some of it doesn't. All of that was background to what is now my decade-long foray into Medicaid, which in the US is a program of healthcare for those in poverty, and in particular my focus on those who have developmental disabilities, which are a primary cause for them to be living in poverty. And this was an almost accidental field of study for me, brought into it by some friends who were familiar with my work, but were not working in a field I had previously had anything to do with. So let me provide some, what I think are some general comments about algorithmic decision making, and I'll try to tie that back into the particular experiences of the litigation that I've been involved in. I think the promises of AI and algorithms in public decision making are really found in the problems that they are utilized to address. And so there are some opportunities here to solve some problems. As Joe already pointed out, complex decision standards exist in many public programs, sometimes far too complex to be easily applied by unassisted humans. And so where there are such complex standards for decision, it seems certainly that algorithms may provide a good solution there. In circumstances where we are dividing scarce resources among multiple competing demands, that again presents a complex set of problems that might be amenable to algorithmic decision-making processes. Another thing we're seeing here in the US is where algorithms and like Joe, I feel that a lot of these things are described as AI or algorithmic when they're really not that complex. But a lot of times these are being used to avoid liability, legal liability for decision making by creating at least the appearance that decisions are made on an entirely objective basis to overcome the fear that discretion, for instance, might invite certain types of discrimination. And then finally, as a quality control tool to determine if decisions are being made consistently by humans, AI can certainly provide review services to identify where decisions are varying from person to person or from situation to situation. The reality of these systems is what those of us in litigation end up facing. And the reality of those systems, as I've seen them, essentially have at least 5 primary problems, which sounds like a lot, but I'll keep it brief. First, these systems are often used for what are not particularly complex decisions. Deciding whether an employee should be in some way, should have a demerit for missing a shift at work is not a complex problem. And yet it's one of the first places I saw automated decision-making being employed on a large scale here in the US. Second, I think these systems often end up under-prescribing resources in the public benefits setting. Here in the States, we've got a federal government and 50 plus state governments. And state governments, by and large, are required to operate on a balanced budget basis from year to year. And so because of that system, over-prescribing public benefits is seen as the far greater evil by the administrators of those systems. And so the systems end up often being built to under-prescribe the available resources. Third, they are often replacing discretionary decisions with what are in fact arbitrary decisions. And that's been the experience in addressing Medicaid, the healthcare program here in the US in the cases I've worked on. Sometimes it's done what I think is intentionally. Statistical tools for building decision trees and algorithms routinely rely on averages, means, medians, rather than on a finer analysis of need. And so an arbitrary decision is made, or arguably arbitrary decision is made that, if certain conditions are met, then there is an average award of benefits that will be provided. But it also can arise, and actually a little farther unintentionally, in the cases I've worked on, we also find that there's an intentional decision made to meet only a portion of the population's needs. So for example, in a case called KW versus Armstrong, which was against the state of Idaho and its Medicaid system, the state routinely, intentionally designed its system with the expectation that 15% of benefit recipients would receive an award of benefits that was almost certain to be inadequate for their needs, and inadequate for the needs that the program was supposed to address. And so there was an intentional under-provision of services there. But it also happens unintentionally, and that is often by the administrators of such systems simply using inappropriate statistical tools. Again, in the case I worked on here, the state agency used a multiple regression analysis based on prior benefit awards, and then applied a technique known as best fit to evaluate different possible algorithms that could address that. And that had the effect of cooking in, so to speak, the biases that had driven the prior system. And so to get a little more detailed, the program we found when we dug into this had taken a population of approximately, I think at the time it was 4,000 individuals, looked at their detailed plans of service, which are written plans that describe how they will use their public benefits to meet their particular needs arising from developmental disability. Took those plans, which had to be approved by the agency, there were budgets assigned to them, performed that regression analysis against a wide variety of factors that they thought might be relevant, that the agency thought might be relevant to establishing these budgets, and determine to what extent did this wide range of factors actually affect the cost of the plan that was actually approved for each individual, and then generalize that. We got some very odd results from that. And one, for instance, that stuck out was this particular population of benefit recipients and this particular population of people with disabilities and their needs were relatively stable over time, unlike the situation that Claire described, where an individual's need might change from month to month. These were individuals whose need under this program was quite stable over long periods of time, decades long, in fact. And yet, the age of the individual, the calendar age of an individual became a determining factor that reduced benefits. And so older participants were consciously and intentionally assigned slightly lesser benefits than a person who was otherwise identical but younger. And that was the result of the fact that over time, the assessment of individual need by humans, that had been done by humans, had changed. And so people who had been in the program longer tended to have lower budgets than those who were new to the program, and they tended to be older. And so that ended up getting included in the algorithm. So we have both intentional and unintentional arbitrariness that results. The fifth major problem we've seen, or I've seen, is that these systems tend to prevent system users and or participants from understanding, sometimes intentionally, the reasons for the decisions that have been made about their benefits. And to give what I continue to find to be an amusing anecdote on that, what was described as the budget tool that determined what was the value of benefits that each individual in this program would receive, would result in people receiving a budget anywhere from a few $1,000s to $180,000, $200,000. So there was an incredibly broad range. And of course, individuals budgeted under the system would like to know, well, why did we receive a particular budget? And for many years, they were told, we can't tell you because that's a trade secret. Now, of course, this was a state agency claiming a trade secret, which was problematic for them in a number of ways. When the budget tool was described, it was described as an incredibly complex multiple regression analysis-based system that resulted in a detailed algorithm that distributed the budget. As it turned out, what the system actually did was it took an incredible amount of data in a large number of different categories, but then relied on only 6 items of data to set budgets for everyone. And in fact, far from being a difficult and complex algorithm, it was a simple spreadsheet, literally a spreadsheet. It was used, it was operated in Excel, the Microsoft program. And it was easy, once it was finally disclosed, it was easy to see that this was a highly arbitrary system. And it was that arbitrariness in US law that gave rise to a claim under our Constitution. And those claims, they vary considerably. It sounds like they're not too far off from what Claire describes, where she talks about the arbitrariness of the system and the irrationality standard that had to be met. We have a similar issue here in that in order to prove a violation of our Constitution on these terms, one has to prove that the system is entirely arbitrary and would result in people who are otherwise identical receiving different benefits. And we were able to prove that. The other part of the problem we discovered was just the incredibly poor quality of the underlying statistical work. It may be entirely possible that the private sector can do a better job here, or does a better job in things like algorithms for Google searches or other search engines. But when the state agency was assigned the task of figuring out a system, they relied on a woefully underqualified statistician. They did not properly vet his work or the decisions he made on how the system would operate. And so it was, plus there were enormous problems of the system was based on an absolutely horrible sample of prior service plans. So we ended up with a bad sample utilizing the wrong statistical analysis, yielding a result that was intentionally arbitrary because it excluded the top 15% to avoid outliers, and then was also unintentionally arbitrary because it did things like it awarded fewer benefits, lower benefits to people who were older. It shockingly to me, it awarded lower benefits to people who suffered a higher number of seizures on average. And so we were able to convince a court to enjoin utilization of the system in 2011, 2012, and we are still now 10 years later, only on the cusp, not yet there, of implementing the new system that will replace it, which is considerably more robust, considerably more valid, but still suffers some of the same problems. So 10 years later, we're looking at a new system here that, for instance, the sampling that was done to create the system excluded one whole portion, about 20% of the population at issue here. So I think the conclusions from the work in this field are that the complex systems that often lead to more complex algorithmic decision-making are oftentimes the systems least suited for that kind of decision-making. I think the immigration story, the UC story, and what I've done here, demonstrates these were all circumstances that require a level of human discretion to apply things like, determining what is an individual's need for medical services. Second, I think another conclusion at this point is that such systems tend to fail for some similar reasons. One is, bad statistical work on the front end. If you can't describe the problem to begin with, it's difficult to create a good algorithm around it. Second, they tend to have overly rigid rules built into the algorithm because that's precisely what they're trying to do, is replace discretionary decision-making with rule-based decision-making. And finally, that lack of human oversight to spot and correct the errors, to exercise the discretion where it is needed, also tends to be a feature of this, and it's something we're working hard to ensure gets included in the replacement system. So that's been the experience here, which is interesting because it tracks so closely with what we just heard from Claire and Joe about problems in their respective fields. Happy to answer, of course, any questions in more detail about the work we've done on the system here, as well as any more general comments that anyone would like to hear. Thanks for having me.
Great, thanks, James. That was really, really useful and really, beginning to knit together all the different experiences of this. So finally, last but not least, we have Geir McAndrew, who's a barrister at Moncton Chambers, who's going to talk to us about the data protection aspect of AI algorithm decision making. So over to you, Geir. You're on mute.
Classic error. Sorry, everyone. Good evening. Thank you, Alan. It's a pleasure to be with you this evening. I'm going to spend my 10 minutes talking a little bit about the data protection rules and how they fit into the perils and promises of AI and algorithmic decision making. Data protection is essentially a shorthand term for a set of rules that govern how information about an individual can be used by others. To break it down to its simplest formulation. And in essence, it's all about balancing the fundamental rights of the individual to protect their personal information, and in a lot of cases, their identity, with the needs of society to use data in a range of ways that, if done properly, as Alan alluded to in his introductory remarks, can be very beneficial. In the UK, the relevant rules are set out in the Data Protection Act 2018 and the UK General Data Protection Regulation. Now, the latter piece of legislation is originally derived from the EU, but following our withdrawal from the European Union, it was incorporated into domestic law and continues to apply. The data protection rules themselves and technological advancement, they're intrinsically linked. When the first data protection legislation was introduced in the UK back in the early 1980s, which was actually relatively late compared to some other European countries, the government argued that it was needed because the rapid growth in the use of computers posed a threat to privacy. Now today, of course, data protection rules are required to grapple with a whole range of new and constantly evolving ways in which technology is used to process data. And in particular, the topic of this session, algorithmic decision-making and AI, where personal data is a necessary input into the processing. And as Joe said, it's still unclear how existing legal standards are going to be adapted to accommodate these new uses of data. We're certainly in the infancy of figuring that out. And in my view, a lot of public bodies haven't really taken on board the need to mainstream data protection concerns into their use of algorithmic decision-making, but they are a key part of how the law is going to grapple with this and any resulting problems in the future. So in the time that I've got this evening, I just want to focus on a few of the data protection obligations that are particularly relevant when you're thinking about algorithmic processing or AI use by public bodies. A number of the things that I'm going to mention apply equally or similarly to private companies, but it is, of course, of particular importance to observe data protection rules when the processing is being done by a public body, an arm of the state, because, you know, look at the examples that we've had that have been referred to this evening. It's the state who decides if you get benefits or who you can marry, for example. So it's really important that the protections are observed in that most critical of contexts. Before I get into that, just a very quick crib sheet for anyone who's not studied data protection law before. I'm going to be talking a lot about processing personal data, and in essence, that just means personal data, that's any information that identifies or could be used to identify an individual. So, you know, obvious things like your name, your email address, your date of birth, possibly your location in certain circumstances. There's also a separate category of special data, which is particularly sensitive, and that applies where its misuse might have really profound effects on the right of the individuals. So, for example, that would include data which relates to somebody's ethnic origin or religious belief. It can also include biometric data, which is a type of data that's increasingly being used in algorithmic or automated decision-making. So, for example, facial images, which are captured by surveillance cameras, which then can be used in facial recognition technology, which a few police forces around the UK have sought to deploy. When I talk about processing, that means any operation or set of operations which is performed on personal data. It's extremely broad. It means collecting, storing, recording, destroying personal data. So, of course, putting personal data through an algorithmic decision-making tool or an AI software program would count as processing. So first off, UK data protection law imposes a number of obligations which apply whenever personal data is being processed. So regardless of whether you're using an algorithmic tool or not. And people who are doing the processing or deciding how the processing is being done, they must comply with the so-called data protection principles. There are a number of these, and most of them have at least some relevance to algorithms and AI. But for the moment, I just want to concentrate on the first principle, which is that any data processing must be lawful, transparent, and fair. Lawful means there's got to be a lawful basis for the processing. Those bases are set out in legislation. They include things like consent, carrying out a task in the public interest, compliance with a legal obligation. But as Joe alluded to in his presentation, the legal basis must be clearly identified, and that's not always the case ex ante before an algorithmic decision-making tool has been deployed. The requirement of fairness is also particularly interesting in this context. The ICO has issued guidance which indicates that means that your data processing must be both statistically accurate, and avoid discrimination. So statistically accurate. If you're using an AI or algorithmic system to make inferences about people, you've got to ensure that the system is sufficiently accurate for the purposes for which you're using it. It doesn't mean it's always got to be 100% right. As Alan said, even really high grade systems, you're probably only getting to about 90%. But you do need to factor in the possibility that it'll be wrong and include safeguards for that. So if your algorithm is spewing out incorrect results, you're going to violate this principle of data protection law, as well as other public law principles as well. The requirement to avoid discrimination, and we've heard tonight that the robustness of the results that are produced by algorithms and AI, their quality will depend on the quality of the data that's fed into them. And if you've got data which is already biased or contains pre-existing biases, then it's highly likely that the algorithm will reflect those biases, and any processing of personal data in that way is likely to be a breach of this principle. So for example, an algorithm used by the Home Office that ranks people based on their nationality and applies different standards of scrutiny depending on whether they're deemed to be highly suspect nationality, neutral nationality, or positive nationality, to use the want of a better word, would probably fall foul of that requirement. And you may all well remember the use of algorithms by a number of governments, including ours, which used an algorithm to predict grades when students were unable to sit their exams as a result of COVID-19. Now, there was speculation at the time that some of these algorithms could themselves have had discriminatory impacts, because their predictions were based on the historic performances of students who'd attended a particular school. And so that could lead to differences in outcomes depending on whether the candidate in question had gone to a historically high-performing school or a less well-performing school. The challenges in the UK never really got off the ground, the legal challenges to the Ofqual algorithm, because the government changed its mind. But a similar type of algorithm was used in Norway, and the Norwegian Data Protection Authority said it's not fair and it's not accurate. And so therefore it violated the first data protection principle. And finally, just quickly to touch on transparency, you've really got to understand, you've got to make it possible for the people who are affected by your algorithm to understand how it works. And that's sometimes now referred to as explainability. And it's really important when you're using potentially complex systems, or even where you're using basically quite a simple algorithm that may be still quite inaccessible to the people whose data is being inputted. And so you've got to explain to them what's going on, how it's going to be used, and how it will generate results that will impact on them. UK data protection legislation also contains a number of obligations which are specifically aimed at the use of technology for data processing purposes. So people have, first, the right not to be subject to decisions which are entirely automated and which have a legal or similarly significant effect on them. And this means entirely automated. That means a process where there's no human input or influence on the outcome. Now, we've canvassed over the course of the evening that actually having a human input can be really important when you're making decisions, because it introduces an element of discretion which may not be present in the automated system. And under data protection laws, there's a protection against that absence of human decision making. The qualifier is that it's got to be something that has an effect on your legal status, or it's got to have a significant effect on some other aspect of your life, so your circumstances or your choices. So a social security process which automatically evaluates how much benefit you receive, similar to what Claire was talking about, and there's no human input, that would be based on automated processing. And of course that would have potentially a legal effect depending on how it was done, but also a similarly significant effect on your livelihood and your welfare. This also applies to profiling, this requirement. So profiling is automated processing of personal data, which uses the personal data of individuals in order to evaluate their likelihood to do A, B, C based on certain things that you know about that individual. So for example, predictive policing, saying X type of person is more likely to commit a crime. If there's no human input in that, that's profiling and automated processing. automated processing is permitted in limited circumstances. So say, for example, where it's necessary to perform a contract or you have explicit consent, and that must, of course, be obtained on a fully informed basis so people really understand what they're consenting to. In most circumstances, the person whose data is being processed has the right to say, no, actually, I want a human to at least have some oversight of this process. The other relevant right or obligation that I want to touch on is the obligation to conduct a data protection impact assessment. And essentially, this is trying to mainstream data rights protection into the development of novel data processing uses. So the obligation to conduct a DPIA applies when the processing in question uses new technologies and where, taking into account the nature, scope, context, and purpose of the processing, it's likely to result in a high risk to the rights and freedoms of natural persons. So obviously, if that applies, then the data processor is under an obligation to conduct an impact assessment, basically, where you have to identify a whole range of things, including whether the particular processing is actually necessary, if it's proportionate, properly evaluate the impact that the proposed processing will have on the rights of the data subjects in question, and consideration of what safeguarding mechanisms, if any, you can implement. So that's really trying to ex ante encourage public bodies to formulate any algorithmic decision-making tools in a way that is compatible with the fundamental rights of the data subject. There's also a range of individual rights, so it's not just obligations, there are rights. The right to be informed that you're subject to automated processing, the right to object to it, and the right to access your personal data that's being processed. They all apply to algorithmic decision-making, equally. Just one point on I'm conscious of my time, just one point, the government has recently consulted last year on a new kind of data, it's called Data A New Direction is the consultation paper. And it contains a number of things which relate to data protection laws, including in particular the right to have automated decisions taken by automated processing overseen by human. That's now being proposed to be stripped back, and that's caused understandable concern to quite a lot of data rights campaigners. And it's also a marked kind of divergence, possibly one of the first and the most notable, between the UK regime and the EU regime, where the trend is very much towards heavy regulation of AI and algorithmic decision making. So with that, I think I'll hand back to Alan. Thank you.
Thanks, Keir, that's great. One of the things I really dislike about sharing sessions that I'm actually interested in is I then get to hand over the questions to the audience rather than to me. So we've come to that point. We've had a really fascinating views into different parts of the public sector and the operation of algorithmic decision making, which have all kind of knitted together as we've gone along. So if you have any questions, feel free to pipe up now.